Fabiana Di Porto, Henry Mostyn, Marco Botta, thank you very much for agreeing to discuss the Digital Markets Act. I propose we start with just trying to remind ourselves the key milestones of the procedural of the entering into force of the DMA and starting its effectiveness, its application to the gatekeepers. Henry, could you just very briefly visualize to us the evolution?
Sure. So the DMA was first published by the Commission in around Christmas 2020. And then it entered into force just last week on November the 1st, 2022. So the whole thing from soup to nuts took under 2 years, which is really quite extraordinarily fast for legislation of this scope. For comparison, the GDPR was proposed on the 25th of January, 2012, and it entered into force in 2016 and became applicable in 2018. So that was about 4 years in the legislative process. So this was much, much quicker, and I think as fast as the Commission was hoping. In terms of looking forward on what's coming up next, the DMA will become applicable on the 2nd of May, 2023. And there's a few key dates you've got to keep in mind for what's going to happen. There's 2 months from that date, the gatekeepers will have to notify their core platform services. That's an acronym that we'll come on to discuss a bit more through the talk. And then the Commission will have 45 days to designate, to decide whether those core platform services fulfill the qualitative and quantitative designation. So sometime between 3rd of July and September next year, there'll be a decision from the Commission designating those CPSs. And you'll see it reported September 2023 is the date everybody has in mind, because they assume the Commission will take those 45 working days, which it probably will. There's then a 6-month buffer before the main behavioral rules come into force. Those are the rules in Articles 5, 6, and 7. We'll come on to discuss what those rules are, I'm sure, in some more detail later on. So that takes us to around February, March next year, the drop dead date for the behavioral rules. But importantly, some other rules, like the obligation to do with merger notifications in Article 14, they take place immediately upon notification. So that will be around September 2023 next year. So that's the kind of overarching timetable where we've been and where we're going to with the 2 years coming up.
And obviously, we understand that for such a paradigmatic change, every of these periods matters, and thus we can envisage, we can anticipate some juristic probably problems already at this stage. Should we, or is it will be kind of very smooth and amicable in the first time before the substantive provisions will enter into force?
That's a very interesting point, Oles. I think it's really up to the Commission in the coming months to establish a sort of dialogue with the gatekeepers. I think the Commission is trying to do that. For instance, beginning of December, the Commission will organize a workshop on self-preferencing with the interested stakeholders, so to try to explain already in concrete terms of what are going to be, let's say, the obligation for the gatekeepers. And I think there will be other similar events before the entry into force in May next year of the DMA. So to me, it's a bit unclear at the moment if the gatekeepers will start with a hard position going for litigation on every act adopted by the Commission in the implementation of the DMA, or if they will have a more, how to say, amicable position, let's say, and they will, in any case, it's a binding regulation, so it's better to negotiate with the Commission and to get some kind of obligation which smooth, the burden of the obligation with them. So for me, this is still open and we have to see in the coming months. In case they go for litigation, I think there are 3 possible stages of the litigation. One would be, as mentioned before, the possibility to challenge at the General Court the Commission decision designating a gatekeeper. Because in Article 3 of the DMA, you have clear turnover thresholds, clear thresholds based on the number of users, business users and end users, but it's also written in Article 3.5 that the potential gatekeeper can provide substantially substantiated arguments to rebut the evidence of the gatekeeper positions. I do believe that at the beginning, the Commission will reject this type of arguments, let's say more qualitative, to say, no, we are actually not gatekeepers in the markets. Also because the Commission will receive a lot of notification at the same time in May next year, and I think will reject this possible type of argument. So in that case, the companies will challenge the Commission decision in court, the General Court and the Court of Justice. Then the second possible litigation is after the designation of the position of gatekeepers. The gatekeepers have 6 months of time in order to comply with the obligation. But for Article 6 and Article 7 obligation, the Commission can adopt a decision to specify in concrete terms the obligations for different gatekeepers. And I think the Commission will do that because my opinion, these obligations are quite general. So again, another decision that can be challenged under Article 263 of the treaty to the General Court and then to the Court of Justice. And then very late in time, I would say, in case of non-compliance with the Commission decision, with the obligation of the DMA, then the Commission can adopt fines and really after, I think, 8 years, I can even impose structural or behavioral remedies. Again, possible decision to be challenged in court. So really the gatekeepers at the moment have 2 possibilities: to go very hard, resist the enforcement of the DMA and challenge every act of the Commission in court, or to be, let's say, to have a bit more friendly position with the Commission. I think it would be better for them. But let's see. Fabiana.
Okay. Oles, thank you for the invitation, first of all. To me, I would like to raise another point which relates to the cooperation between the Commission and national competition authorities, because I think this will be really crucial to the, if you want, the effectiveness of the DMA, considering that the Commission is understaffed. And if you want to really, if the Commission wants to really be proactive, as it seems, to enforce the DMA, in a way, it would need the support of national competition authorities. However, if we take a look at the DMA and the way it is formulated, this is really far from easy. Because in a way, Article 38 is the one that is relevant in this discussion. First of all, the DMA does not really clarify that the authorities that will be in charge of supporting the Commission in the enforcement of the DMA are national competition authorities. And this is not really clear, because Article 38 actually says that those who are to collaborate with the Commission are national authorities in charge of applying competition rules. And this is far from clear, because in national member states, this can be different authorities and not necessarily one authority, but they can be more than one. And also this can be identified by national laws, and eventually national laws can identify more than one authority. And also, if you read the way Article 38 is drafted, it says that national competent authorities of the member states enforcing the rules of competition law are not the only authorities that will be in charge of aiding and cooperating with the Commission. But these are also those, and I just quote, that apply rules prohibiting other forms of unilateral conduct insofar as they are applied to undertakings other than gatekeepers or amount to the imposition of further obligations on gatekeepers. So what does it mean? And this is really relevant because it is actually left to national laws to establish not only who those authorities will be, but also what the powers of those authorities will be, and in what way those authorities will contribute to market inquiries and to investigations, and if they are giving wide powers or not wide powers. And this is absolutely crucial if the Commission wants to pursue an effective implementation of the DMA.
I think in the version adopted by the Parliament, it was even more pervasive, explicitly mentioning national regulators, sectoral regulators, and some others. So the final version is a little bit more compact in a sense, but still leaving these backdoors possible. Yeah, Henry, do you want to reflect on these two points? On the board?
I was just going to reflect a bit on the litigation points raised by Marco, if I may. I mean, I completely agree. It's not clear to me how much litigation there will be, and I don't think success for the Commission looks like a whole load of GAFAM companies clogging up the General Court for years and years. Yeah, I think there's a shared interest in the Commission and the GAFAMs in showing that the DMA can work, right, rather than years of litigation. And but that said, in terms of what litigation can look like, I also agree, Marco, some interesting points there. Maybe just a few additional reflections from me on that. Whether certain services fit into those qualitative categories in Article 3 that you mentioned is super unclear. And so I'd encourage maybe your students to look at those definitions in the DMA and then think about new services that some company might apply and, try and identify, is this an online intermediation service? Is it a number independent interpersonal messaging service? Is it a social network? I mean, it's super not clear to me. These are not hard and fast rules. We have fixed ideas how things might apply, like Google is a search engine, but for new services, it's not clear at all. On the 5.3 exemption you mentioned, Marco, sorry, 3.5 exemption you mentioned, you're quite right, that could be an area. You might have seen just a few weeks ago, I think a Microsoft representative mentioned that Bing is over the threshold to be designated, but they'll be arguing for a 3.5 exemption on the basis as a low market share. I think that might be quite tough because the wording of the recital specifically says where the Commission will not accept the market definition type arguments. Third, and it's still related to this idea of what is a service. It's not just designating a service, but under the DMA, where a service starts and where a service ends is super important for some of the rules. So for some of the rules, like you cannot share personal data or combine personal data across a CPS and another service without user consent. Clearly, it's critical, where does the CPS end and where does a separate service begin? And under traditional competition law, there's a test and there's a framework in cases going back to like Microsoft on how you identify separate products. It's an open question how the DMA will apply that. And the annex of the DMA has a rather cryptic reference to purpose. The purpose is how you will identify the scope of services. And I could imagine that might be something that's subject to some debate in the future. And then just finally, I can't resist mentioning that there is an open question that people have written about, that the DMA has been brought under the wrong legal instrument. It was brought under Article 114 of the TFEU, which is the article for achieving harmonization across the internal market. However, there's a different provision if the EU wants to give new powers to promote competition in the internal market, and that's Article 352. However, the critical difference is Article 352 requires unanimity among member states, whereas Article 114 does not require such unanimity. So there may be an open question that if the DMA is introducing new competition rules rather than just seeking to avoid fragmentation of the internal market, was brought under the wrong legal instrument. And so that might be something that you see discussed in the years ahead.
and not only discuss, probably we already hear very authoritative voices trying to somehow to fuel this conversation about the selected, I would say wrong, the selected, the most probably the only realistic legal way to adopt the DMA. So it would be quite interesting to see whether they would be ready to start the discussion at this most foundational, so to say, point, challenging the validity, I assume, yeah?
Right. I think you could only have a challenge once there was a decision with some legal effect, right? And then as part of your appeal of the decision, you would say the instrument it was brought under wasn't brought under the wrong legal instrument. So that could be a decision to designate a gatekeeper, or it could be one of the decisions, you know, to impose a fine for a breach of the behavioral obligations. But that could be something that people are thinking about for the future as well. And it's been written about publicly a fair bit, and your students can find articles about that as well.
You mentioned in passing, Henry, an issue which is not on the list of our, you know, general questions for discussion, but which is quite interesting overall. Bing and Microsoft. So Bing would meet the supposedly that would qualify as a core platform service, and thus we would have a situation which is very easy to model. Essentially, we have one clear-cut, obvious undertaking which is dominant in many senses of kind of ex post competition law, and we all understand that it's for the Commission it's a challenge to somehow to trigger horizontal competition in such online search engine markets. And then we have a potential newcomer in this business. He is not new, but it's still, you know, a potential driver for competition here, which would be somehow constrained from competing and exploiting or using the opportunity which the DMA creates for the potential competitors. How do you evaluate this situation? Is it advantageous, or is it just fair, or
I mean, it's interesting. Perhaps just a few reflections. So, as everybody, in case your students don't know, the way you designate a service is based on qualitative and quantitative criteria. So you have to have one of the set defined types of services. Yeah, a search engine is one, which Bing is. Then you have to have your group has to have a market cap of 75 billion euros or 7.5 billion revenues a year. And then the key thing is the service must have a user threshold of 45 million monthly active users and 10,000 business users. And if you satisfy those things, and that you have to satisfy those for the last 3 years, then if you satisfy them, there's a presumption that you're in. And Microsoft has said publicly, well, Bing is quite a used search engine. It has over 45 million monthly active users, and so it falls under the presumption. So they'll be arguing for this exemption because they have a low market share. As I said, it seems quite hard. You're quite right. It leads to some possibly not what the legislators were intended when they were drafting it. Well, actually, it's hard to say, but you know, if Bing has to comply with the rules, it will have to comply with all the rules. And so there's some strange outcomes. You might imagine there's a rule, Article 611, which requires gatekeeper online search engines to share the data of their users to other search engines. So you now would have the strange outcome that Bing, the number 2, has to share with the number 1 the data of its users as well. And so, yeah, but that's how the DMA has been written. And Article 3.5 is clear that the exemption will be interpreted very strictly, and market share arguments are not going to be accepted.
So let us then move on, but still within this kind of through the perspective of potential litigation. We obviously been in this discussion for 2+ years. There were many engaged, nuanced debates on the nature and the substantive provisions of this, when assuming that they may enter into force smoothly. And we can have two polar views, essentially. Some say that the obligations, at least obligations of Article 5, but also many obligations of Article 6 are clear enough, they are detailed, they are self-executing, they're supposed to be self-executing, and they are in some sense. Others say that they are open-ended, are the extreme, let's say, and there are many positions in between, and that, as we all understand, any adjective opens the door, particularly if the stakes are so high, opens the door for interpretation, and thus it's being not open-ended, but it has clear penumbral meaning, so to say. Do you envisage again? What is your view, essentially? What is your assessment in terms of the substantive provisions? How carefully and accurately they are designed from the procedural, from the juristical, linguistic point of view?
Maybe I can start this time, Oles. So generally speaking, without going too much into the details of the individual provisions, I'm more for the view that these are quite vague and open-ended obligations, which will have to be then shaped later on by the Commission decision. Why that is the case? First of all, because both in Article 5 and Article 6, we have a mix of de facto obligation, so positive obligations are the gatekeeper shall do something, like, I don't know, as mentioned before, sharing data with competitors, and negative obligation, prohibition de facto, which is something very close to prohibition in competition law. So for me, this is already something not fully clear. Then the second point is that most of the provision in Article 5 and 6 are addressed to every gatekeeper, rather than to the gatekeepers operating in the specific core platform services. And as a matter of fact, it's very difficult, let's say, to, at least from the wording of this provision, to adjust this general provisions to the specific business models of every gatekeeper operating in different core platform service. Even Article 5, which is supposed to be self-executing, to me, it's far from being self-executing. For instance, take Article 5, paragraph 2, paragraph B, subparagraph B, which is the obligation for the gatekeeper to keep data silos, so not to mix together data collecting from different core platform services, so to avoid conglomerate effects. So how you do it in practice, I really don't think this can be done by the gatekeepers directly without at least a monitoring side from the Commission.
Just to agree with you on that one, 5.2b, you point out, I mean, it's quite interesting to us. It has the notion of you cannot combine personal data, and then in C, cross-use personal data. The notion of combine or cross-use is not defined in the DMA, and it is not defined in any other legal instrument. So this is supposed to be an easy to understand rule, but it is not defined what this means at all. So you're quite right, Marco. How this is, people are going to interpret and apply this needs some careful thought and dialogue between the gatekeepers and the Commission.
Here's just an example, but there are many examples. I think most of the paragraphs in Article 5 and 6 are, to me, quite unclear. Also, I don't know if you think about interoperability. Interoperability is something extremely technical. It's not sufficient to write in the law that different services have to have interoperability. So this will require, as I mentioned before, a lot of dialogue, technical dialogue between the Commission and the gatekeepers, which will go on for years, and the Commission will have to monitor the implementation not only of Article 6 and 7, but also Article 5, which in my opinion is far from being self-executed.
Yeah, I absolutely agree that even in Article 5, when we would assume that there is more clarity for having direct effect of these provisions, also there is a lot of margin for not only interpretation. We as jurists will easily find the way to interpret even the most clear provisions. So this is not the point, but true that there is a lot of unclarity in the way provisions are drafted. So for my work, I know that even the most clear words can be interpreted and used in different ways by different stakeholders, and this is particularly true for words which are new, and even for locutions and expressions which are not familiar to stakeholders. So I would say that especially for provisions for data silos, which were mentioned by Marco previously, that combining personal data would be very, combining personal data would be very uneasy to apply. But having said that, I think that gatekeepers, I mean, the problem would not really be whether this is unclear or clear to the gatekeepers, because guidance can be provided by the Commission on how to apply those, or even the workshops that the Commission is organizing is really in the direction of providing the gatekeepers and even the constituencies, even national competition authorities or the traders, more clarity on how to apply those provisions. To me, the clarity should come onto the idea that we should move away from the idea that these are antitrust provisions. These are not antitrust provisions. Let's make the case for self-preferencing. We are still in the idea that we should apply self-preferencing, we should look for some theory of harm. This is not the case. Self-preferencing as we know it from the antitrust praxis is corresponds to at least 5 provisions in the DMA, because what was prohibited in the Google search case is now, let's say, prohibited under the non-combination clause, Sherlocking clause, and several other practices which are now forbidden in the DMA. So there is no complete correspondence between the conducts that were forbidden in several antitrust cases and that are now forbidden in the DMA. So this is something that should be the more and more understood by practitioners who should be, let's say, educated to make use of the DMA.
So basically, there is even in terms of semantics, the vocabulary. We can see the intentional attempts to disentangle the continuity. Obviously, we all understand that the rules are inspired and driven and motivated by the not failures but challenges which we face in enforcement of ex post rules. But they should not be pursued and applied through the lenses of these practices. So it's used, it's regulatory tool and legal ground 114, as you mentioned, Henry, earlier, is one of the reasons here, of course, that, or it can be interpreted as one of the reasons for not associating it directly with competition rules as we know them. And yeah.
Just the word, maybe to clarify a little bit what I just said. Self-preferencing in the Google search case was made of several conduct. So we had the demoting of competitors' conduct, which was made through altering the algorithm and showing the results in the search engine in a discriminatory way. Okay, this was one of the conduct, and the other one was also using the data commercial data of traders in order to compete against them. These two conducts are now forbidden in two different articles of the DMA. Okay, so while we were searching for a rationale, and we have been debating for years to look for what was the competition harm for self-preferencing, and we have been debating for years to establish whether self-preferencing was a substanding competition law infringement or not. Okay, in the logic of the DMA, these are just two different law infringements, and these are per se law infringement. So we would not need to demonstrate any competition harm, okay, because these are just per se rules. So the logic is completely different, although they have been inspired originally, but although the DMA has been originally inspired by the same logic as the Google search case. Okay, so probably the origin was the same, or even better said, the DMA rules on shell-locking prohibition, which is using rivals' data to compete against them, and the discrimination in rankings prohibition is also originates from the Google case. However, we now have to use these rules as per se rules and in a different logic. That's
so combining.
Just to avoid misunderstanding, the use of business data to compete, that's not in the Google shopping case. That's the Amazon marketplace case, actually, that's ongoing at the moment. That there was no allegation of that in the Google shopping case. So that's the Amazon marketplace where Amazon has offered commitment.
All right. So basically, if we based on these two questions which we just discussed, whether clear or not, whether obligations are understood by the gatekeepers or not, or whether there is sufficient substantiation in the logic of ex post competition law or not, they will become binding. So we all somehow see that the standard of proof for the DMA is significantly decreased. Essentially, it's much easier now to demonstrate things which were much more difficult to demonstrate in the classical competition vocabulary and mechanics, so to say. So can we infer from this, that's my next question, that such low-hanging fruits have been tailored specifically for public enforcement and exclusive enforcement of the Commission, and we cannot mechanistically extrapolate these competences in these two dimensions in terms of national competition authorities, one dimension, and private enforcement, or it would be too bold statement in your view? Can we start now with Henry, probably?
Sure. So on the standard of proof, I mean, the Commission will still need to prove a violation of the rules to the applicable standard. Yeah, it will still need to prove it. What's different to competition law is that it doesn't have to take certain of the steps that it would have to do under competition law. For example, defining a relevant market, identifying dominance, showing an anti-competitive effect, and assessing objective justification. But it will still need to show that the conduct that the gatekeeper engages in violates the rule as written, and then some of the rules also have their own specific carve-outs. For example, if the gatekeeper can ensure that compliance would endanger the integrity of the OS or the hardware. If I understood well, you're asking now about the private enforcement in national courts of the DMA. As with all things DMA, I think it's not super clear. And it's actually become even less clear following some developments over the last week. In terms of background, the original draft of the DMA said nothing about private enforcement in the national courts. But the final version does include a provision on the interplay between the Commission and national proceedings. That's in Article 39. That doesn't directly say that national courts have the power to enforce the DMA. But it does implicitly suggest that national courts will have the right to apply the DMA. And that would also follow from like general principles of European law, that private parties, as you know, can invoke EU regulations if the rules in question are sufficiently precise, unconditional, and confer rights to individuals. So that's all subject to one caveat that I'll come to in a moment. But the main question then would be, if that's given the framework, how far the ability of national courts or private parties would actually go in applying different provisions of the DMA. And I think there are good grounds that only the Commission has the power to designate a gatekeeper, because that's a task reserved to the Commission under Article 3. And I think there's grounds that only Article 5 could be invoked, because Article 6 and 7 are particularly they don't have those sufficiently precise, unconditional, and confer rights to individuals. There may even be an argument under Article 5, as Marco described, given how uncertain some of these concepts are, like combined, cross-use, and so on. And now I should just say a word. There was a judgment just from last week. I don't know if anyone's read it, in the DB Stations case. We're still fully getting to grips with it, with what that means. But it was a question referred to the Court of Justice about whether private entities can seek damages in national courts based on 101 when the subject matter relates to the decision by a sectoral regulator. And the judgment's a bit cryptic, and I'm personally still making my way through it. But it seems to be saying that a private party cannot invoke a secondary regulation in a court before the applicable regulator has taken a decision. And then once you have a decision, you can have a follow-on case. But there couldn't be a standalone case prior to the decision of the applicable sectoral regulator. And if you applied that reasoning to the DMA, that would mean you could not invoke the DMA directly in the national courts prior to the commission of a decision. I think we're still we need to see what that judgment quite means, but that's how some are interpreting it, at least.
Marco, do you want to reflect on this issue?
Yeah, indeed, the interesting private enforcement of the DMA. It's a very interesting topic. So first, what is private enforcement? Let's say, so we're talking about damages actions and the request for injunctive relief for injunctions. I don't really see damages actions coming in the near future, in the sense that first we must have the DMA enter into force, we must have a gatekeeper designated, and then the obligation starts to run. The violation of the obligation has to generate a damage to potentially, I don't know, end users or business users, and this one go to court. So this is really far in the future, and I don't even know if this will take place. Injunctions might be possible, let's say, in addition to public enforcement, monitoring by the Commission and by National Competition Authority, in terms of forcing the gatekeeper to comply with the obligations. I see the point mentioned before that we will have private enforcement for Article 5 obligations because they are self-executing. I agree with that, but I will not exclude private enforcement for Article 6 and Article 7. Why? Because if you read these two provisions, the language is still binding. The gatekeeper shall comply with this list of obligations, Article 6, and then there are specific obligations for the interpersonal communication services in Article 7. The DMA just say that in Article 8 that the Commission can specify, may specify, the obligation of Article 6 and 7 via a separate decision. But in theory, the Commission could also not do that, let's say. So I think there will be a bit more space for private enforcement beyond Article 5. I think it will be mostly in terms of injunctions, requests for injunction by competitors of the gatekeepers for violation of the obligations. And then we also have one provision, which is Article 42 of the DMA, which refers to Directive 2020-1828 about representative actions in the field of consumer law. This directive entered into force in 2020. and basically has the objective to somehow generate a sort of class action, collective redress in Europe. So reading the directive a couple of days ago and Article 42, I was wondering if this would be really a legal basis for a group of end users harmed by a violation of the DMA obligation to go to court under Article 42. Personally, I have serious doubts because the directive from 2020 use a system, let's say, without going too much into the details, which is very far from the American class actions. You don't have punitive damages. You have an opt-in system rather than an opt-out system. And also you don't have contingency fee for lawyers. So you have, let's say, actions by, I would say, consumers associations, let's say. So I don't think we will really see a lot of actions by group of end users under Article 42 against the gatekeepers. But once again, I think we will see at a certain point some actions by competitors of the gatekeepers for violation of the obligation under Article 5, 6, and 7.
Well, on this, I'm not totally in line with Marco's views. On the contrary, I think that this is a very interesting provision, and that it is also in line with one of the probably unwanted consequences of the European Parliament's intervention in the negotiations of the DMA, which somehow broadened the scope of the DMA, making it shift from one purely pro-competitive text to a more, let's say, consumer protection text. Well, let's say the balance is still a little bit is still more in favor of the competition interests, of course, but we can see that out of the negotiations and in the latest version of the DMA, which was adopted, some consumer protection interests were introduced, and this article especially was the result of this negotiation. What I mean is that allowing for collective redress and class actions is a way to transfer some of the collective welfare onto final consumers, and this is one of the goals of the DMA, because the DMA, if you want, is based on the assumption that gatekeepers are somehow unmovable. There is no contestability of those operators, and because these are not contestable, and there is no other means to dislodge those people that then regulated them. And therefore, if they behave in a way that is non-compliant with the obligation of the DMA, then the damages that they may cause onto consumers, then they have to somehow compensate. And the means the legal system provides to consumers to have those damages compensated is collective redress. one of the means, of course, but probably one of the most effective should be, of course, in reality, it is not because of the way it is designed in this directive. I agree with you, Marco, that it is not so effective because of the way it is designed, but in an ideal world, it should be, it should be effective. Okay, so in the design of the DMA, it makes sense that that provision is there because the DMA has somehow included those pro-consumer interests in its final version. So it makes sense that that provision is there. That's my opinion.
And we also infer from Article 42 being added there last minute, essentially, the logic of which Massimakis Komnenos was trying to develop in one of his papers before, that essentially that there is a room to remove private enforcement even from the obligations which are directly effective but not necessarily directly applicable, and thus by stating explicitly only collective redress as the form of private action, we essentially implicitly imply that private actions, at least standalone private actions, are less somehow envisaged in the framework, or it would be too far-reaching suggestion. It is probably too far-reaching suggestion. Okay, we will see. But still, interesting, Marco, that you have noted that it's opt-in system. Yeah, so it's unlikely that we will see such, not only US, but also in the UK, we have some examples.
If I'm not mistaken, there is a difference. For request of injunctions will be opt-out, and for damages compensation would be an opt-in system, if I'm not mistaken. But again, I'm not an
that
expert
is worth for everybody.
Yeah, and I think the directive was adopted in December 2020. So I think it's still very early to assess the degree of enforcement and implementation of the directive, which is designed, as Fabiana was saying, for consumer law protection issues, and then at the last minute added, let's say, this reference to the DMA into the DMA in Article 42.
Right, let us move now then, if I may, to the issue which has been discussed also quite pervasively over the last time, the provisions of Article 13, and again quite recently in one of your landmark events at the European University Institute, Marco, one of our participants, Fabiana Di Porto, has articulated few very appealing arguments about the application of anti-circumvention provisions in conjunction with the substantive obligations. Fabiana, may I ask you please to remind us the key thesis of this point?
Yeah, sure, with pleasure. Yeah, basically my argument is that Article 13, especially 13 paragraph 4 and 6, is not just a repetition of the provisions and prohibitions and obligations of the DMA, but rather it enlarges or especially its acute can broaden the scope of those obligations. It states that gatekeepers cannot undermine the effective compliance with obligations of the DMA. And also, by saying that, it extends the liability of gatekeepers to those practices that are not implemented by behavioral techniques or interface designs or by any other means. So, and paragraph 6 even further extends those responsibility with an even more penetrating requirement. It basically states that gatekeepers that should treat users in a neutral manner and should not impair the exercise of their rights by subverting their autonomy, decision-making, free choice via the structure, design, or function or operation of user interface. Now, what is a user interface? If we think, for instance, to the IoT services or products, which was actually the subject of that seminar you were mentioning before, we should think to those entry points of smart devices, like, for instance, voice assistants or sensors or applications like that give us access to smartwatches or TV sets or home appliances. All those categories would fit the category. All those things will fit the categories of interfaces. Now, the goal of those anti-circumvention rules is clarified by recital 70, which says that what is forbidden to gatekeepers is all those practices which are not immediately visible, such as contracts, for instance, but reflect more subtle practices. Which can be non-neutral practices, which use the structure, function, or manner of operation of a user interface to subvert or impair the user autonomy, decision-making, or choice. These are basically referred to as dark patterns. Dark patterns are very, very widely known in literature, but are especially annoying, like cookies, for instance. And we we are unaware of the use of those things by digital operators, which are not just the gatekeepers, but in this case, we are dealing with them. So let me just make a few examples of that. And of the way Article 13 may enlarge the scope of applications of the obligations and prohibitions of the DMA. So again, Article 5 of the DMA and the prohibition to combine data. This is the concern behind this prohibition is the accumulation of data by the gatekeepers. So if we take Article 5, it basically establishes that unless users are presented with a specific choice and have given explicit consent under the meaning of the GDPR, the gatekeeper cannot sign in users to access several services of the gatekeeper. So what Article 13 does essentially is to extend the prohibition to situations where the signing in of users is facilitated by practices known such as nagging. Nagging consists of repeatedly interrupting the course of action that we do while providing our consent to data processing. Or, for instance, repeatedly requesting that a recipient of a service consent to data processing. Such practices are very, very common, as we know. Or let's make another example. For instance, self-preferencing. We also referred to it previously. Self-preferencing in Article 6.5, gatekeepers cannot treat more favorably in ranking or in indexes its own services and products compared to the services or products of third parties. So again, gatekeepers are requested to treat their own competitors in a non-discriminatory way to apply transparent and fair conditions to such rankings. What Article 13 does is basically to, again, enlarge and extend the responsibilities of gatekeepers. Just to make an example, Google or Amazon do embed their services, like for instance, Amazon Music with their Alexa voice assistant product by default. And they would be prevented to do so unless they show also rivals services, like for instance, Spotify, but also Google Music or other providers, other minor providers. Not only that, but they will also allow the Commission to force the gatekeeper to change its interface design if this demotes or competing services by a practice like prominence, which means giving more visual prominence to any consent options when asking the recipients of a service for a decision. And that would be illegal, which is not clearly the case if one only reads Article 6.
Indeed. Henry, what would be your reflection, or either on Article 13 as such, and maybe also in conjunction with Fabiana's reading of these provisions?
I think it's an interesting analysis. I suppose I maybe see it slightly differently. I think, it's normal in any antitrust decision, for example, to have an anti-circumvention clause. So in any remedy, you will say, in an antitrust remedy, it will say the company who's the addressee of the decision shall not engage in any measure that has the same equivalent object or effect. And that's sort of broadly similar to what you see in Article 13.4, the anti-circumvention clause. They just add, regardless of whether that behavior is of a contractual, commercial, or technical nature. My personal view is that even if Article 13 was not included, this would follow as a matter of proportionality, right? So if a gatekeeper sought to circumvent the rule, it could still be a problem without that anti-circumvention clause. So I'm not completely sure that it does widen the obligations that fall under 5, 6, and 7. It's just clear that the gatekeeper cannot circumvent those rules, which is what would apply anyway, in my view.
Marco, do you want to reflect upon these issues as well?
Yes, I found very interesting that Harry referred to anti-circumvention clauses in antitrust decisions, because I think that's the origin of this provision. So in antitrust, we are used to have an open list of conducts that are in breach of Article 101 and 102, developed with the time via the case of the Court of Justice. The DMA, it's a regulation where we should have a fixed list of obligation in Article 5, 6, and 7, fixed list of obligation which should provide at least also some legal certainty to the gatekeepers about what they have to do in the market. So I'm more sympathetic with the view expressed by Fabiana, that this Article 13 is very far-reaching because it's included in a regulation, in ex-ante regulation, rather than in an antitrust decision. So if I read Article 13, paragraph 4, the gatekeeper shall not engage in any behavior that undermines effective compliance with the obligation of Article 5, 6, and 7, regardless of whether the behavior is of a contractual, commercial, or technical nature. This gives a very broad margin of discretion to the Commission when the Commission will adopt decisions specifying the obligation in Article 5, 6, and 7. So we'll have to see. So this is also what we were discussing before. So the origins of the DMA are in antitrust, let's say. And I think Article 13 is one of the examples that show that the DMA comes from antitrust and then it has developed in something else. So we will see to what extent the Commission will use this type of discretion.
But do you think if, again, from the pure vocabulary, if we talk about anti-circumvention, do we envisage intent, or it's just, it's not necessarily intentional, you have to prove the intent?
13 paragraph 4 does not mention any intention, any behavior that undermines effective compliance. I don't see intention here. Anti-circumvention is in the title of Article 13, but then it's not mentioned in Article 13, paragraph 4. So personally, I don't see the need to prove intention.
I invite you to read paragraph 6, which is even more demanding than paragraph 4.
I'm mindful of time. I wanted just to, after zooming in the specific provisions, I just wanted to move closer to the end of our meeting by maybe asking two last questions. The first one, if you imagine the situation in, let's say, 3-5 years time, who do you think the DMA would deliver? Who would be the main beneficiaries? In what respects it will be more satisfactory and beneficial for which market supply element of market supply chain it would deliver, for which the expectations are very high? I know it's just crystal ball discussion in this stage, but crystal ball discussion by competent contributors.
I mean, from my perspective, it is difficult to say at the moment. I think one thing that I hope is that the Commission, in the enforcement and interpretation of the DMA, does consider all the different stakeholder interests, because there are often multiple stakeholders at issue: consumers, small businesses that rely on the platform, rival platforms, smaller rival platforms, and the gatekeepers. And these interests are not always aligned. And I think it's really important the Commission is thoughtful about balancing these interests. And actually, that's what the Commission, as Marco and Fabiana has mentioned, it has these workshops coming up, one on preferencing announced for December, and possibly one on interoperability in 2023. And it'll be really important that all the different interests are represented there, not just the gatekeepers and not just the rivals, but the consumers and the small businesses as well. I mean, just to give one concrete example. So 611, we discussed requires disclosure of search data. Yeah, so the data that I enter into a gatekeeper search engine, which could be Bing or Google. Yeah, the smaller rivals, obviously, so that's the queries that I enter, some embarrassing medical query I might have entered this morning, for example. Now, rivals obviously have an interest in receiving that data. That's the whole point of the provision, because it's said to be a barrier for them competing because they don't have access to such data. But me as a person, I also have an interest in my search data not being shared with unlimited rivals, including rival search engines that might be owned by hostile states. For example, Yandex, I think the EU's official journal has noted the Russian government has a golden sharing. And so you have two competing interests here. Yeah, you have the interest of users who don't want their private information shared, and you have the interest in rivals who obviously want to get as much data as possible. Now, the rule expressly requires for anonymization of the data. So the European legislator has already taken this into account, but the devil will be in the detail of the enforcement, right? Because what is anonymization is a matter of degree. And so you'll have to think about, we have to balance the interest of the rivals and the users in trying to come up with a reasonable way to comply with this rule. But that's just one example. I think I could give many, many others where the different interests of users, businesses, rivals, gatekeepers are sort of, you can think of them as four pieces of a puzzle. And I think it would be just very important that all these interests are carefully considered in the application and enforcement of the DMA.
Thank you, Henry. Fabiana.
Yeah, well, there are really several interests. I think that 2 to 3 years time is really ages in digital terms. And maybe we might envision the metaverse coming over, and the DMA will be too old to tackle all the troubles that will be coming with the metaverse. and biotechnologies being entrenched and attached to the digital. So we will have to start a new drafting and revising the DMA. This is just a joke, but I think that lawyers and attorney will be benefited by the DMA. And second joke, and then I don't know. To be honest, I see that as we've been discussing in the beginning, there will be probably a lot of adversarial output in the beginning, probably in midterm, as Marco said, and then in the end, as Henry said. So I cannot really forecast that. I mean, from me, doing a lot of computational and linguistic research on antitrust and now on the DSA and DMA and Artificial Intelligence Act, I'm very happy that I will have access to all of your data, including the three of you, of course. So I will be searching everything. Being a vetted researcher, I will access all of it, and hopefully they will be anonymized by the gatekeepers, and so don't worry.
Fabiana, please say that it's the third joke.
It is a joke, and it's
thank God.
But I
Marco.
do computational law. That's true.
So indeed, it's very difficult to say who will be the winners and losers of the DMA in 3 to 5 years from now. So first I would say, what are the goals of the DMA? Fairness and contestability. I think in terms of fairness, we can forecast, let's say, that indeed the DMA brings a bit more fairness in digital markets, in the sense that it prohibits several conducts which were unfairly imposed by the firms controlling the digital ecosystems on business users and end users. So I think this will be achieved. Then the open question, and nobody can really give an answer, it's whether the DMA will increase contestability in digital markets, whether it will really open up digital markets and we will have competitors of GAFA. This is something that we don't know. It's very difficult to forecast at the moment. I personally think that the main beneficiary of the DMA will be the platforms not subject to the DMA obligations. And if I'm not mistaken, the Chinese firms are those ones which are not subject to the DMA obligation. I'm talking about TikTok, Alibaba, and so on, because simply the number of users and turnover in the EU at the moment is very low. So I can foresee in 3 to 5 years that their presence in the European market will increase a lot. And then the question is, are we really willing and happy to share our personal data with them? I don't know, let's say. So there might be some negative consequences of the DMA, which are a bit hard to foresee at the moment. For business users, as I said before, there will be a bit more fairness. Think about the small vendors selling products on Amazon in competition with Amazon, let's say. So there will be some rules helping them to compete more fairly. For end users, I don't really see any big advantage from the DMA. So the ability to disinstall some how to say, some apps from your Google Android, who really cares? Or to transfer your personal data more effective from one platform to another, I don't think really end users will rely on this possibility. So to sum up, I think 3 to 5 years from now, some winners, some more competing platforms of the gatekeepers, Chinese firms, some companies which would be to some extent better off, but this comes, let's say, case to case. It would be the business users and end users. For them, the situation will not change dramatically.
So thank you for implicitly suggesting 3 further topics for our future workshops, because these questions articulated by all 3 of you are really tempting to continue our conversation. But let me finish with asking you, again, speaking about the 3-5 years time framework, you obviously observe, being deeply in this matter, you definitely observe many new opportunities and many new kind of competences which this new situation requires from the new entrants in the profession. What would be your suggestions, recommendations for young law students, law graduates who want to connect their career with this very promising and ongoing, rapidly evolving area of law and policy? Let us start with Henry first.
That's a good question. I would probably, mine would be is maybe don't focus so much on now at this point on dry legal text and too much academic debate, but to try and follow the policy debate, as written, on Twitter, follow what's going on in technology, try and read, envisaged articles, try and read what's going on in tech, and see how it plays out as a first step, and because there'll be plenty of time for dry legal text as your career progresses.
Fabiana?
Okay, I have 3 recommendations. The first one is continue to study antitrust, as it will not disappear. Digital is not all life, and its principles will continue to inspire the application of the DMA for some time on. Consider classes on regulation, and thirdly, enhance your study, your education on data science, which is necessary to understand digital markets and more broadly on whatever is around us.
Excellent. Marco, please.
Yes, I agree with Fabiana, definitely. I think we will have more and more litigation in courts, more enforcement. So I would say there will be a lot of jobs for lawyers in this field in the coming years. But at the same time, I agree with Fabiana that lawyers who want to specialize in this field should also have some kind of technical background. It's something very difficult, at least in continental Europe, to combine a law degree with a degree in data science or any other technical subject. But I think for the next generation, this would be really important.
Excellent. So let me thank you first for your really remarkable observations, insights, ideas. I'm very grateful for sharing them with all of us. Fabiana, Henry, Marco, thank you very much indeed, and I hope we'll meet again at some point in the future to discuss how correct our speculations and forecast was.
Thank you very much.
Thank you.
Thank you, Oles, for the invitation.